Hello everyone, thank you very much for joining us today for our webinar. We're going to be talking about commercial leasing masterclass, so navigating the risks involved with renewals and also the legislation. The Property Law Act has recently been updated in 2023, which took effect from the 1st of August this year, 2025. So we're going to go through some of the provisions in the new legislation that affect leasing. So a little bit of an introduction to myself and NB Property Law. So my name's Kayleigh Swift. I'm the director here at NB Property Law. So we specialise in commercial and residential property matters. I bring a broad experience from both private practice and also local government, and am quite experienced in advising clients on complex leasing matters, acquisitions, and also property development projects. I've got skills set as well required in estate planning matters, whether it be drafting complex estate planning documents or estate administration or probate matters. I'm also quite passionate about helping my clients and advising them on their own estate planning documents and assisting executors to help them navigate the complexities involved in the legal responsibilities and their financial responsibilities as executors involved in an estate administration matter. So our agenda for today, so we are going to go through what the risks and benefits for tenants and landlords are in leases. We'll go through the rent review essentials. We're going to talk a bit about lease renewals and the demolition clauses that are included in leases. We'll be speaking about dispute resolution strategies that are drafted into leases as clauses and how they operate. And we're also going to go through the new consent procedures and the liability changes that have been introduced as part of the new Property Law Act, as I mentioned, that took effect in August of 2025. And then we will have a bit of time at the end if you do have any questions, which I'm happy to answer for you. So to start off with, we're going to be talking about the actual holding over period. So most commercial leases, and when I'm talking about a commercial lease, I'm talking about either a retail or a non-retail lease in Queensland. So most of these commercial leases will include a clause that allows a tenant to continue to occupy the premises on what's called a month-to-month basis after the actual lease term is ended. So generally in a lease, you will have a lease term, which could be, a 5-year lease period, and you could even have options to renew that. Now, the option might not have been affected. The lease term has come to an end, or maybe there were no option periods. And therefore, if you are remaining in the premises, or you've got a tenant that remains in the premises after that expiry date, they're in what's called a holding over period. And during that period of time, the lease will generally stipulate that it's on a month-by-month basis. So you can stay in the premises and allow tenants to stay in the premises month by month. So, at any point in time, you need to give a month's notice for them to vacate and obviously make good the premises if the lease allows for that. Now, there's both benefits and risks for the landlord and the tenant in doing so with a lease holdover period. So for the tenant, we've done a bit of a table up here to outline them. So some of the risks for the tenant is there is no certainty that a new lease will be agreed by the landlord. So while you might be negotiating for a new lease, and that could be, taking several months to try and get one, and you think you're maybe at the tail end of those negotiations, there's nothing stopping a landlord then saying, no, we're not proceeding forward with a new lease, and you've got to get out within 30 days. And then you've got 30 days to obviously find new premises for the business and actually, negotiate a lease within that period and be able to remove into those premises. Hopefully no fit up period is needed, because you're not going to be ready to go and start running the business at that point in time. The other risk is the tenant will generally increase during the period. So while the lease has expired, generally the lease will have provisions that it increases by, maybe CPI or fixed increase on the anniversary of each lease date. So, yes, it might have expired in the, prior to expiring, you're paying X amount. It doesn't mean that it's not going to still increase in that holdover period. The other thing is there's limited leverage if the landlord wants you out quickly, which kind of covers off on that first point. Like I said, they at any point in time can just give you 30 days notice, and you've got to be out, within that 30 days, which is a short period of time when it comes to a business looking for new premises and making sure that the construction and the fit out of them is ready for you to go into. The other thing is it can be potential strange if disagreements arise. So, while everything, sometimes we've got landlords that have got tenants in a month by month premises and they've been doing so for a long period of time. But if there's a breakdown in relationship at any point in time, obviously 30 days is all that's needed then to get them out of that lease premises. Now, the risks obviously to the tenant, but with risk there's also benefits for the tenant. Now, the benefit from them is that it does allow them time to finalise arrangements while moving to alternative premises or while the lease terms are agreed. So, it may be that the tenant didn't intend to actually carry on the lease and they have found alternative premises, but there could just be a little bit of period extra rather than the lease expiry date that's needed. So, they just might need an extra 2-3 months to do so to get everything finalised without locking them into a further, 2 or 3 year lease. The other benefit for tenants is it does allow them to continue to operate without immediate relocation. So, like I said, they can still operate their business from those premises while needed until they are ready to move somewhere else, or maybe they're shutting down the business on something altogether. It can also allow for the tenants to use time to actually negotiate better lease terms. So, negotiating a lease can take a long period of time. So, while the original lease might have expired and a new lease is being negotiated, sometimes that can take, several months. And so if that wasn't instigated prior to the expiry date and, well in advance the expiry date, then those lease negotiations could still be taking a few months to get them finalised. The last benefit that we've noted here for the tenant is that it does preserve the goodwill if handled cooperatively. So if parties are in agreement, it can be, quite advantageous for the tenant to just be on a month-by-month lease. The risk for the landlord, though, so there is no clear deadline on if or when the tenant will move out, making it harder for them to secure a new lease. So, again, the same risk, poses for the landlord. If the tenant provides 30 days notice to the landlord that they're going to be vacating, that's not really a long period of time for a landlord to get the property marketed, and find and secure a tenant and have, a whole lease negotiated. So there's likely going to be, quite a bit of downtime where they're not actually receiving the rental income and, they've got to then go to market to find someone else to take over that rent and that lease amount. Another risk for the landlord is that can face disputes with the tenant if the tenant's disputing that higher rent that's being charged. So, if the lease is expired and then the landlord wants to then increase the rent by, the CPI or fixed increase, there's nothing potentially that the lease didn't allow for that, and it just kind of had a holding over period but no actual clause on what the rent would increase by during that holdover period, then obviously dispute can arise from the tenant and, the landlord could be accepting a rental payment then that's inferior to what the market dictates they could receive. The tenant can also delay the landlord's plans for redevelopment or new tenants. So, if the landlord did have plans to redevelop or they've got new tenants in the wing, by allowing, the old tenant to continue on the month-by-month basis could mean those, are obviously delayed or at risk of losing that new tenant. Obviously also could be a higher risk for conflict or legal action. One of the reasons I mentioned there could be, the rent that's being charged. Conflict could be from a various different things from the tenant. They might not be wanting to do the make good works or something like that. Again, though, there are still benefits for the landlord. The first one we've got listed here is that it allows them to ensure the premises are actually occupied while a new lease is being finalised. So if it is just formality, so the existing tenant is actually planning to enter into a new lease and they're just in the process of finalising negotiations, getting that lease drafted, at least obviously everything is continuing as normal and rent is being paid in that period. It does also allow for higher rent charges for a short-term arrangement. So, the landlord could say, obviously happy for you to stay here on a rent by rent, a month by month basis, but however the rent's going to be at, X amount, whatever the landlord decides to charge in that period, which could be higher than what the market is, knowing that it's just for a short term, for example, while the tenant's getting ready to move into their new premises. Another benefit for the landlord is that it allows them to keep the property occupied while searching for a new tenant. So they're still receiving that rental income in the back end while they're finding a more secure long-term tenant for that space. And it does also show flexibility and strength, which can strengthen that landlord-tenant relationship by allowing them to stay on as just a month-by-month tenant. So that's kind of, yeah, benefits and risks for both tenant and landlord. You know, you need to weigh it up, obviously, noting these when it comes to holding over periods though. Now, rent reviews in a lease. So often you will have an initial rental amount that's included in the lease document, but then obviously there are rent reviews that will take place. So as I mentioned, in Queensland, we've got, you know, the retail shop lease and then a non-retail shop lease. Now, those retail shop leases, they are covered by a particular piece of legislation known as the Retail Shop Leases Act, which was enacted in 1994. And now this does have limits on the rent review methods that can be used. Any other leases, you know, commercial leases in Queensland are considered non-retail shop leases. And so these aren't covered by the Retail Shop Leases Act, and that allows the lease to contain clauses that allow the landlord to choose the rent increase method, which allows them to actually increase for a higher amount each year. So there are a few common types of lease increases that, you know, are in place that are commonly used, and that's CPI. So based on what the actual CPI is what the rent will increase by, which is often on the anniversary of the lease commencement date. The other thing is we can increase rent by a fixed increase. So that could be a fixed percentage. Now, you know, that you know, varies. It could be, you know, a 3% increase each year. It could be a 6% increase. You know, it could be somewhere in between is often what we see, and that, you know, changes with the times depending on what the market's doing as to what that percentage will actually be. And the last one is the common one is a market rent review. Now, market rent reviews, they're generally a market rent will take place on the day that the option period commences. So if we've, for example, got a 5-year lease with an option period of maybe, you know, a 5-year option, a market review generally is at the commencement of that option period. So often the rent review will be either CPI or fixed increase on the anniversary date of the lease, and then a market review upon the option period being enacted. Sometimes as well, leases can also have, you know, CPI or fixed increase, you know, whatever the higher amount is. So that can sometimes have both of them in there, and it is whichever's higher at that point in time. Now, we're going to talk about lease renewals. So, you know, we kind of spoke a bit about it, you know, with the holdover period. You know, we've got, you know, initial term, it's come to expire, and therefore we obviously need to look at maybe renewing the lease. So a lease renewal, it's not an automatic right, and it must be included in the lease. So to ensure that the lease is renewed, the tenant will need to ensure that they provide notice within the timeframe specified in the lease. So when the lease does have an option period included, so generally with that option period, it's up to the tenant to notify the landlord within a certain period of time that they wish to take up the option. So often that might be, you know, up to 6 months. You know, they can notify them anywhere from 6 months, but no later than 3 months prior to the lease term expiring. You know, the reason for this is from the landlord's point of view. As I mentioned earlier, it can take them quite some time to find a new tenant. So they need to, you know, have prior warning as to whether the tenant is continuing with the lease, because otherwise, obviously, they need to go to market and find someone else to take over that space. And that's why, you know, the strict timelines are in the lease for a tenant to actually decide if they want to take up the option for renewal. So the tenant has an obligation, though, to comply with the method of notice outlined in the lease if they do wish to take on the option period. And generally, that's just providing written notice to the landlord, or the landlord may have appointed a property manager to look after the lease that they wish to do that. If that particular notice is not given within the correct time frame and by the correct method, then the landlord can refuse the renewal if they have issues with, you know, the landlord, or potentially if the landlord, if the tenant is actually in breach of the lease. So, you know, if the tenant hasn't, you know, got outstanding rent that hasn't been paid, or if they've, you know, gone and damaged the property and they've been issued a breach notice that's not been remedied, then, you know, under no circumstances are the landlord required to agree to extend the lease for the option period. The tenant will be able to apply to the court for relief, though, if the landlord has, doesn't actually have the grounds to refuse the option renewal period, and they've just gone and done so on their own accord. But like I said, if the tenant is in breach at the time, a breach notice is given, the landlord can refuse the renewal of the option period at that point in time. Another common clause that are included in a lot of commercial retail leases in Queensland is a demolition clause. Now, demolition clauses are included, for various different reasons. I think one of the prominent examples that we've seen in Queensland in recent times was after the 2022 Brisbane floods. Many people probably know the Toombul Shopping Centre, and basically all of those businesses' leases were terminated under a demolition clause. So it is a triggering clause, and it can obviously have some quite severe impracticalities, for a tenant if there is a demolition clause in a lease. So it is something to be aware of when you are looking to enter into a lease, and also for a landlord's point of view, if they're entering into a lease to potentially have a demolition clause if you're a landlord. But obviously from the tenant's point of view, you really don't want that demolition clause in there, because it could mean that your lease is going to come to an end quite suddenly. Obviously if it is included in there, potentially needing to negotiate, time frames and, maybe even compensation around it. So a demolition clause is also known as a damage to premises or a destruction of premises clause. It obviously allows the landlord to terminate the lease if the premises become unfit for occupation. The landlord's not required to provide compensation, though, to the tenant if they terminate the lease under this clause. So, that's a big one, because, like all these businesses in that Toombul Shopping Centre, all of a sudden, business shut down, no longer got any premises for their business to go until they go and source somewhere else, and the fit out that they may have even just done is essentially gone down the drain. A retail shop lease, though, will provide some protection under the legislation in terms of compensation and things like that, but it is still quite limited. So demolition clauses, they are included in a lot of business leases, but then they obviously have quite significant impacts for tenant, but obviously for landlords they can be beneficial, because it means that they're not having to completely pay an expensive bill to repair a property that's kind of beyond repair. The aftermath of unexpected events can it's going to leave the tenants vulnerable, but obviously from a landlord's point of view it's just not feasible for them to actually repair the damage done. Generally tenants with commercial leases, they're in a worse position. So, there's no, unlike the Retail Shop Lease Act, there's no actual separate act that governs commercial leases from being regulated, by demolition clauses like retail leases, where, retail tenants, they have a little bit of extra protection under that Queensland Retail Shop Leases Act. In particular, a section in here allows that the landlords, may be required to actually compensate a tenant for the cost of loss or damage that they've suffered as a response to the lease being terminated under the actual demolition clause. In terms of obviously tenants insurance though, so regardless of whether the business lease is a retail or commercial lease, obviously a tenant can always have a look at giving themselves an extra layer of protection just in case their lease is terminated early. And the key for tenants is obviously to take out adequate insurance, in particular when it comes to considering demolition clauses. Tenants may wish to look at taking out insurance policies such as flood insurance, contents insurance, and obviously business interruption insurance if their business becomes interrupted, in that period of the property being demolished and finding new premises. So it's always important to talk to your insurance broker or provider to get a policy that suits in those circumstances. Make good clauses. So when a tenant leaves the premises, there's often make good requirements that are needed. These are often included in leases. It's not just about cleaning up and moving out the tenant's possessions. That that's not the case. It may also require any or all of the following. So if you've done extensive fit out works as a tenant, often your responsibility is to bring the property back to a bare shell that it was in when you you took up the actual lease. Sometimes, you know, there are extensive fit outs done, and it can be included in the lease or negotiate with the landlord that the fit out remain, so that you don't have to basically bring it back to that bare shell, but that, you know, it needs to be done at the outset of the lease as opposed to when you come to terminating, because, you know, if it comes to terminating, you're not under, the landlord's under no responsibility to agree at that time. And make good, you know, it can be quite costly. You're still needing to get in all the trades and things to bring it back to that bare shell. And sometimes, you know, it's going to include, you know, things like repainting walls, you know, replacing, you know, broken ceiling tiles, or replacing flooring and things like that. It could also mean, you know, restoring basically the premises to the condition it was when we started the lease. So it is a, you know, big obligation on tenants to make good at the expiration of the lease, and that needs to be done, you know, on the date that the lease expires. It doesn't mean that you know, the lease expires, you know, for example, today, and then, you know, you've got the next month to then work on the make good. You know, you will still be paying rent until the make good is done. And often, if it's not done, then obviously the landlord has recourse against the tenant, whether that be, you know, utilising some of the securities they have in place by way of the security bond. It could be, you know, relying on personal guarantees by the directors if the lessee is a company, and then obviously, you know, potentially looking to make a claim for further damages if that still doesn't cover the amount. So what if the lease doesn't have a make good clause though? So if the lease period is for longer than 3 years, the lease still has a requirement, the tenant, sorry, has a requirement to keep the premises in a clean condition regardless of whether there is a make good clause in the lease, and this is under the actual Property Law Act. So it imposes an implied obligation on the lessee to yield up the premises in a good and tenantable repair, and determine what is a good repair and in a condition fit for occupation. The condition of the premises at the commencement of the lease should be taken into account. So this means that even if the lease does not include a make good clause, the legislation still requires the tenant to clean and make good repairs to the premises so that it may be in a condition that a new tenant can occupy it. It's also good practice for a tenant to clean up the premises before they vacate, and, you know, by leaving the premises in a clean and tidy condition, a tenant may be able to make maintenance repairs that they were, you know, obligated to do under the lease clauses. Dispute resolution strategies. So often, you know, we've got a lease, it's for a long period of time, you know, a big amount of money, you know, disputes can often arise within that term. So there's sometimes ambiguity in a lease as to, you know, what the terms mean, you know, who's responsible for what. So this is kind of just like a 5 steps to avoid or reduce the actual disputes that can arise within leases. So we need to ensure that the lease terms are clear and precise, in particular the maintenance, repair, rent reviews and make good clauses. That's often when disputes will arise. So, you know, making it really clear, like I said, about make good clauses as opposed to having to rely on the legislation. Rent reviews, you know, we've gone through that, you know, what it should say in terms of, you know, rent reviews, when they're to take place, how they're to take place. Repairs is a big one, repair and maintenance. So, you know, who is responsible for what, you know, often any, you know, capital works will be at the landlord's expense in, you know, structural repairs, but generally, you know, things like fair wear and tear as well will be up to the landlord, depending on what the lease says. And, you know, things like who's responsible for replacing things like light bulbs, often the tenant, but, you know, we need the lease to actually stipulate this so that we know whose responsibility it falls onto. Another easy way to ensure we avoid disputes arising in the lease is to maintain clear communication. So, you know, you've got a relationship with you know, each other as landlord and tenant for quite a long period of time, generally leases. So it is important to maintain clear communication so that we're aware of, you know, where each other stands. You know, maybe there are maintenance issues. Obviously the landlord wants to know about these. They don't want, you know, to come, you know, time to do a routine inspection, then they're finding about some, you know, thing that's, you know, gone completely wrong with the premises which they own. Also important to document everything. So if there is a change or variation that has been agreed, then it needs to be formalised. So, we've got a formal lease agreement in place. There's no point going and amending this and, in verbally with the other party and not actually documenting this. So, often lease terms can change, and, that needs to be formally documented. In Queensland, we'll use a lease document, and then there's another lease document, known as an amendment to lease, and that's what we need to use to document that. And again, it needs to be signed off by both parties. There's no point just having one party signed it or just documenting and not actually signing off on it. Another important step is to, if we've done this and we've still got the dispute going on, obviously then we're going to engage in alternative dispute resolution or mediation. So the lease, again, there should be a clause in the lease that deals with dispute resolution strategies and what process should be taken. So, often, if it's sometimes with rent, it can be that independent valuer will be appointed to determine what the rent amount should be. Obviously, if it still can't be agreed between the parties, then they'll appoint, someone else to go through that mediation process to help them come to an agreed outcome. But, there will be generally, if the lease has been drafted properly, a dispute resolution strategy to help us work out and come to an agreement on the disputes that are arising. And then, it's important to have these dispute resolution clauses included and, effective strategies for resolving the lease disputes. So, like I said, mediation could be one way to do it, and that'll obviously be facilitated by a neutral third party, and it will offer more of a cost-effective and time-efficient way to resolve the disputes while still preserving the actual business relationship between, the landlord and tenant. It could be as well just negotiation between the two parties. So, direct negotiations with or without legal guidance can help obviously reach a fair compromise for both parties. Otherwise, an alternative to mediation could be arbitration. So, if mediation's not worked, arbitration, it provides a more structured resolution process where an actual arbitrator will be appointed, and they're going to issue an actual binding decision, which, the mediator obviously can't do. It needs to be mediated and agreed by both parties. The legal framework for lease disputes in Queensland with commercial leases, they are governed by the Property Law Act and the specific lease agreements between landlord and tenant. And then understanding these legal provisions ensures that disputes are resolved effectively and obviously in compliance with the state regulations. So, in terms, I guess, of preventing future lease disputes, obviously important to have drafted clear and detailed lease agreements. So ensure that the lease terms explicitly outline the responsibilities, include provisions for dispute resolution. Like I said, we're maintaining clear communication, and then, engaging a lawyer to actually draft the lease document, and advice for clients. So, it is important. Litigation is a very expensive process. So, no one ends up coming out as a winner, and we want to try and avoid having to go to court and go through a long process. And hopefully, a dispute resolution strategy will be the way to do that. And being proactive, getting legal advice, and understanding what the requirements are. New consent procedures. So, with the new Property Law Act, which I said come into play in 2023, but obviously only come into effect from August this year, there are new consent procedures as part of this. So if a tenant is basically wanting to sublet, assign, or share possession of a lease premises, they need the landlord's consent to do that. They can't just automatically do it on their own accord. So the Property Law Act, as I said, it's replaced the long-standing 1994 legislation. So the overhaul, it's introduced significant changes to lease laws, some of which, they're actually applying retrospectively to leases entered into before the commencement of this piece of legislation. but one of them is in regards to the new consent procedures. So the landlord consent the landlord's requirements under this legislation is that they must respond to the tenant's proposals, whether it be, like I said, for an assignment, a sublease, any alterations or change to the permitted use of the premises as well. They've got 1 month of receiving all the necessary information to actually respond to the tenant. They need to issue a formal decision notice stating the conditions for the approval or the reasons for the approval. And then they need to ensure that conditions imposed are not unreasonable, unnecessary, or onerous on the tenant. So the tenant's remedies. So if the landlord does fail to respond on time or act unreasonably, or they impose inappropriate conditions, the tenants may apply to the court for relief. So the practical considerations for this is that leases should include specific compensation provisions if the landlord does seek to claim damages for alterations or changes in the use, as there are no longer expressly mandated under the Property Law Act. The other thing to be aware of is relief against forfeiture. So under the legislation, there's a continued requirement for landlords to issue a notice to remedy breach before the lease terminates. So there's no new obligations here to include notifying designated parties, such as any mortgagees or guarantors or subtenants for the lease. The reasonable time clarifications as well. So the court will determine a reasonable remedy period based on the circumstances, including what the nature and extent of the actual breach is. So if there is any relief against refusal to renew or sell, so where a lease includes an actual option to renew or purchase, the landlord's requirement is that they have to issue a breach notice to the tenant and any other designated parties within 10 days of that breach actually occurring. So they've got to follow the breach notice process, even for technical deficiencies in the option notices. So it's a bit of a big change there. So if the landlord does not consent to the request, they must provide reasons why, and they can, unreasonably withhold the consent in that way. So liability changes as well. So when a lease is assigned, the original lessee and its guarantor will still remain liable. So however, if the lease is assigned again, the new Property Law Act now requires the original lessee and its guarantors to be released at that point in time. So the concept of touching and concerning covenants, it started back in 1540, but it has now been updated. So all lease terms will carry over to assignees or transferees unless they're expressly excluded or personal to the actual parties themselves. So yeah, important to note that one. So that's basically one of the big changes in this new Property Law Act we're seeing. So going a bit further then into the covenant, sorry, I just touched, gone one slide too far. The lessor and transferee can expressly agree in writing that the benefits remain with the lessor, but the lessor will still remain liable for a breach of the lease committed by the lessor. So this applies to both a transfer by the landlord of property or a transfer by the tenant to a new lease. So yeah, we're seeing quite a few changes coming into play with this new legislation. Another one is probably around the actual strict time frames and what the legal consequences are then for failing to take the time to actually exercise that lease renewal, which we spoke about at the start. So yeah, I suppose a bit of a recap. We've seen with this new legislation come into play, changes to how landlords need to actually consent to requests being made, will also the actual procedures that they need to follow in terms of a breach for a lease, and also the compensation we've spoken about today in demolition clauses, noting that Property Law Act doesn't provide for any, but retail leases do provide some if there is a demolition clause included in your lease, and also what are the make good requirements when it comes to entering into a lease for a period of time. So And then obviously we've spoken about, dispute resolution. So how dispute resolution clauses operate in a lease, and, what are the strategies, then to actually avoid disputes arising in the first place. So appreciate everyone joining us today, and I'm happy to take a few questions if we've got any in regards to commercial retail leases in Queensland. I'll give a couple of minutes as well. Either take yourself off mute or feel free to pop them in the chat bar, please. So we've got a question there. Why do you always assume an increase, and what about negotiation? So I'm assuming that's in relation to a market review. So, a market review, it depends on how the lease is drafted. Sometimes a market review, although the market may have dropped and, technically there's been a decrease in rent, a lot of times, from the landlord's perspective, they won't allow the lease to have that, and they'll make it that the lease amount stays the same. So often, with market reviews, it's generally always an increase. Otherwise, it's nothing at all, and it'll just stay as what it was prior to the option period being taken up. Will the liability changes devalue the value that a tenant should pay for the lease, aka their rent? So in terms of that, I think the liability changes you're talking about was what we spoke about before. I don't think that's really going to change the value of what the rent is. It's, it is still, they're still getting the same premises and things like that. So I don't think we're going to see a change there per se. We've got another question there. What kind of protections does the retail shops offer under the demolition clause? So some examples. So the Retail Shop Leases Act, it does give demolition, clauses allow compensation for the actual tenants. It's on a case-by-case basis though, so it does depend on, what is the there's plenty of case law on it, but it depends on, obviously how long the lease is for, how much, their lease was shortened by, what the disadvantage was from the tenant. Like I said, if they've just gone and done this whole new fit out, and 2 months later they've been told that the property is being demolished due to, repairs beyond reasonably expected for the landlord to take out. So, it really does depend on what the circumstances are as to what that actual dollar figure would be. But there's lots of case law around that. We've got another question there. Could you please talk a bit about the redevelopment clause? So a redevelopment clause is actually different than to a demolition clause, so or can be. So you've got a demolition clause, which is if the property has maybe been damaged too far beyond repair for the landlord to carry out. Otherwise, there's sometimes a redevelopment clause that's included in leases that allows the landlord to basically, say that they've got the option to basically terminate the lease if they wish to redevelop the property. It's usually terms and conditions around that. So they've got to give the tenant a certain notice period and provide them a certain period in time for them to basically get out of the lease and terminate it. And so again, if there is a redevelopment clause included in the lease from a tenant's perspective, they need to be negotiating the terms of that as well. Again, you don't want to be entering into a new lease and, at any point in time, the landlord can give 3 months notice to get out. So, sometimes, when we're negotiating for a tenant, it may be that they can't, enact the redevelopment clause to maybe, the option period. So, it could be initial 5-year period, and they know that that's guaranteed. But if they take up the option period, then the tenant could have, the landlord could have the option to terminate the lease under the redevelopment clause. So yeah, they are, a risky clause, obviously, from a tenant's point of view, but obviously very beneficial from a landlord's point of view, because leases are sometimes, quite a long period of time. Like I said, it could be, a 5-year lease with a 5-year option. That's 10 years that the landlord has to sit still and not actually redevelop that property. And, even if you sell a property, provided there's, indefeasible title and lease is registered on title, the new owner, so the new landlord that's been purchased property, they've got to comply with those old lease terms. So if they were wanting to redevelop the property, they would want a redevelopment clause in there to allow them to do that as well. We've got another question there. Could you please talk about, sorry, I did dozens of market reviews as an expert, so not really, a question there. So I think I've answered all the questions so far. Just checking. Just let me know if there's any others that I've missed. Okay. Well, yeah, hopefully I have answered everyone's questions. If you do have any that, you're not, don't want to put your hand up or put in the chat box, then feel free to reach out. My contact details are up there. Just had another one pop through. Does the new legislation that releases the prior lessee and guarantor relate to current leases, or only new ones going forward? So basically, with legislation, it overrides, like lease clauses, in general. So, it is for all leases essentially. Like the legislation dictates, has precedence over what an agreement would say. So it would be, essentially as per what the new legislation would be for that one. But yeah, thank you everyone for joining us. Hopefully you've gained a bit more insight into how leases, both commercial, retail, and non-retail leases in Queensland operate, and obviously how some of the new provisions under the Property Law Act are impacting upon those leases. So like I said, if you've got any questions, feel free to give us a call or send us an email, and happy to have an obligation-free consultation with you about your particular lease concerns. But thank you very much and enjoy the rest of your day.